which many originalists have said we made, we're basically where we've always been. We've actually made almost no progress in terms of the theory. And the only hope, I think, for the theory is to actually instantiate in law school some very serious training in history. Otherwise, people are going to do the same old thing again and again. And I think history doesn't tell you what the law means, but to understand what the law meant at a historical moment is a historical exercise. And I think until we see a greater sophistication, we're going to see a lot more law office history, and we're just going to sort of play the same games we've always played. Anyway, thank you very much.
Well, I don't have a PowerPoint. I just have an old-fashioned handout because I'm one of these old-fashioned originalists. I'm really honored to be here, and I'm really happy to be here. It reached a high of 4 below yesterday in Minnesota. My garage door broke. I had trouble getting to the airport. So really, 24, 48 hours in Northern California. Bring on the rain. It's really good. And I'm really honored to be here with such a distinguished panel and see so many old friends and new friends. So the panel topic is originalist methodology. And so what I thought I'd do, quite audaciously, is I try to sketch out what I thought was correct originalist methodology and see if I could do that in 15 minutes. I'll give you a preview of where I'm coming at. I think I really am Saul Cornell's vampire. And you can tell by the white skin, especially gets really pasty in the Minnesota winters. But I am one of these old originalists. Here, in a nutshell, is my theory. It's more of the objective, reasonable person sort of thing. I think that the task, the enterprise of constitutional interpretation, okay, of explicating the text, basically is one of attempting to discern the objective, original meaning that the words would have had in social and linguistic context, taking into account history, to the sort of generic, average, reasonably intelligent speaker and reader of the English language at the time that the document was adopted. As I was looking over my outline at the airport, I realized that on my whole first page, I didn't use the word Constitution. And it occurred to me that this is actually the method you would use for interpreting just about any nonfiction, oral or written communication. It could apply to scriptural interpretation. It could apply to other forms of legal documents. That interpreting the text is a matter of discerning the actual meaning of the words and the words they would have had at the time that they were written down. The second half of my thesis is that there's a